Welcome back, everyone. Up next, we have a session entitled Natural Gas to Cryptocurrency featuring Ryan Morgan, Chris Halverson, and Bill Kinney. This is going to be a good session to take some notes and go back and share with the kids and grandkids. They'll be interested in this topic. Your session moderator is Ryan J. Morgan. Ryan is the leader of Steptoe and Johnson's Energy Transactions Practice Group, handling a mixture of traditional natural resources and renewable energy projects. His practice involves representation of upstream exploration and production companies, investors, and private equity clients in negotiating complex transactions, operational agreements, and managing strategic business issues. Mr. Morgan provides trusted counsel on acquisitions and divestitures of upstream energy assets, regulatory guidances, and other oil and gas transactions, including joint ventures, participation agreements, joint operating agreements, exploration and development agreements, private equity finance transactions, and related industry contracts. In the past year, he has guided a number of clients with projects using oil and gas in connection with the cryptocurrency mining. Christopher T. Halverson is a founder and the chief executive officer of Pin Oak Energy Partners, LLC, and its subsidiaries. Mr. Halverson also serves as president of Magellan Scientific, LLC, a North American off-grid decentralized digital asset production company. Mr. Halverson is an experienced executive leader in the oil and gas industry with a demonstrated history of creating value in his more than 20 years of corporate leadership. Mr. Halverson began his professional career as a CPA with Hauser and Taylor, LLP, in Cleveland, Ohio. Mr. Halverson is a CPA and holds a dual degree of a Bachelor of Science in Accounting and Finance from Indiana University at South Bend. Bill Kinney is an entrepreneur at heart. He started in the oil business, drilling for Park, Ohio, and running their field operations. He began his own company, Summit Petroleum, in 1984, which he still heads today. Bill is a past association president, Oilfield Patriot Award recipient, and member of the OOGA Hall of Fame. He graduated from Kent State University. He has two grown sons and calls Cuyahoga County home. Please join me in welcoming to the stage Ryan, Bill, and Chris.
Hey folks, good morning. I'm Ryan Morgan, and I'll moderate today. I had a really interesting conversation this morning with Chris and Bill, and I think we're going to have a really interesting discussion today. Let us get a little bit of a feel for the room, if we could, just quickly. How many people in here own any type of cryptocurrency? Wow. Okay. How many people in here have any guess as to how many different types of digital coins are available in the world today? Guess? We don't know for sure, so you're not going to necessarily be wrong, but we think it's somewhere north of 17,000. Okay, about 16,900 of those nobody's probably heard of, and you may not want to invest in. But it's a really interesting space. So I got one more question. So how many people in here feel like, to a high degree of certainty, they know where Bitcoin value will be in 3 years? All right. So we're going to take some bets with these guys. I would suggest 97% of the room would like to take bets with you guys, probably secured by something other than cryptocurrency. So one of the things we know about cryptocurrency increasingly is that a lot of people are interested in it. Very few people have a lot of certainty about where it's going to be and how it's all going to work going forward. Hopefully we can shed a little bit of light on that today. We have some slides that we're gonna put on a loop while we talk, and so don't worry, there's only a few, so they'll come back around several times. Bill and Chris have a lot of interesting things to say, so let's get into that. I thought we might start, Bill and Chris, if each of you could tell us a little bit about what were you doing in life before you got interested in cryptocurrency, and how did you get into that business today?
Well, in my case, what directed us towards it is the dealing with stranded natural gas assets that came out of the shale boom, wells that weren't big enough to get to pipeline and yet were big enough to be productive. And then you have all the issues of plug or produce, trying to get to some sort of operation that will satisfy the state and maybe have a cash flow for the people involved. And I was invited to a meeting. I looked at the idea of generating electricity to produce Bitcoin is what we're after. And I guess the You know, the question, it kind of goes to what you said earlier. Everybody says, you know, what about the future of Bitcoin? So the lead question to that is, if you would have had a chance to buy Bitcoin 4 years ago, would you have? If you had the chance to buy or generate Bitcoin 4 years before that, would you be even happier? So we look at it as it's been fun to have our conversation because we're both kind of generating and holding at this point because the price has dropped off. But what drove us there, anyhow, to get to your question, is stranded natural gas assets. I think it's a great application, regardless of what happens to the price of natural gas. Those assets are just as stranded. The gas is worth just what it was, which is nothing until something's produced. So it's an opportunity for us to produce income out of a stranded asset.
Yeah, and I think, you know, Bill hit on the head. You know, before we got into cryptocurrency, different kinds of, you know, off-grid data center operation, we were in the oil and gas space and found ourselves with, you know, assets that were stranded that didn't have a pipeline to it, that we were looking for some form or fashion to monetize. And this operation of mining Bitcoin at those locations worked perfectly. In addition to that, there's also a revenue enhancement of taking that natural gas, even ones connected to pipelines, some PDP gas, at certain scale, and running them through, you know, generators to generate electricity and through our data centers and mine cryptocurrency, Bitcoin in our particular case, at our locations. And one piece, and we'll get to this later, is I think it's important is, you know, Bitcoin is what we're doing now, but, you know, long term, there's lots of kind of modular off-grid applications for the electricity that we generate. But from where we came from and how we got into this, it's both a similar situation. We had stranded assets that we were looking to monetize that we didn't have an opportunity to do so until now.
Good. And gentlemen, can we start the loop on the slides? So the next question, and you'll see a slide here that maybe gives a little illustration of this as well. For those people who aren't really familiar with what you're talking about, can you sort of explain to us, how do you do this? What do you need? What's it look like out there in the field?
Mind if I take this one?
Well, both situations are pretty much the same. And as you can see here in the center of this one, there's a natural gas-fired generator, a data center, which holds the miners, and from those, some sort of link that's taking that data either via landline, satellite, or in our case, simply a cell modem that ships that data out as it's produced.
Yeah, and actually, I think I'm watching this slide here. We might have a slide that comes around that's a good graphical representation of the kind of simplistic example of how we take natural gas at the wellhead, put it through a natural gas powered generator into our modular data centers that hold a variety of computers you see here on the screen now. And those computers are the computers that are actually, quote unquote, mining for Bitcoin, actually guessing the cryptographic equation. And those are typically connected through, like Bill said, what can be a generally simplistic cellular connection. At every location that we operate, we're able to connect to the Bitcoin network easily through cellular communication. It does not require any sort of special high-speed communication. So at every location we have SCADA or other kind of communications, we can communicate to the Bitcoin blockchain network.
Yeah. And guys, I think there's a different slide deck that we need. There's the one that was over top of this on your computer that has all the slides. If we could get that one to run instead. Right there, there we go. Can we run that one? I think it's on a loop.
Two slides in advance of that.
Can you move that forward? Again?
There we go. Yeah. So this is the graphic that I was speaking of. It's really as simplistic of going from the wellhead on location typically over to a natural gas fired generator or some kind of a turbine, and then into a data center, which is the box, and then you can see there's representation of computers there that are connecting to the cloud in this example, and then generating cryptocurrency, as we mentioned here, Bitcoin. So that's the kind of simplistic representation on location.
What's interesting, and the reason the two of us are up here, is that we represent the two ends of the scale. His is a much larger, his operations are probably 20 times the size of mine. The point of that is that it's all scalable. It really does not require large volumes of gas. It can be done at very small volumes, and then it's a question of application and what your capabilities are, because the market side is fairly open. And, although as there's more mining, the difficulty goes up, and as a result, the yield goes down.
Yeah, but it can be, like Bill said, it can be scalable to very large applications all the way to kind of one-off situations that might use 30 MCF a day on a location powering a 50 kW generator or something of that size.
And so you mentioned the scalability and the differences. So can you give folks who are sitting here thinking, maybe I'm interested, what's an idea of the cost, the initial capital investment you need, depending on the type of scale that you want to go in with?
So there's a market in used equipment, as there always is. So largely the stuff that I've done, we've bought used generators, used miners. We've built our own data centers. So for the 50 MCF operation that you're talking about, for a couple $100,000, you could be up and running.
Okay.
And in the larger application, I mean, sky's the limit. But for larger pieces and some of the stuff you saw before, it could be as much as tens of millions of dollars.
Okay.
So it can be quite a capital outlay.
Okay.
And the juice and the squeeze are pretty close, is what's interesting. So it is pretty scalable in terms of the numbers, which is interesting.
Yeah. So you mentioned a little bit about, what if you could go back in time? We've seen a lot of volatility. If you read the newspapers on this subject, you see some skies falling type of prognostications out there. Do you guys still feel like this would be a good time for someone who wasn't doing it yet to get in, or is there a risk that maybe they've missed their window?
I think now's a great time to get in. Like we mentioned before, like Bill said, we view this with a bit of a long view, right? What's Bitcoin going to be 3 to 4 years out? And the volatility is real. And that's because it's a very thinly traded, global asset that the markets are 24/7 in multiple different places. And so minor activity at the fringe is going to make price volatility bounce around a lot. But I think generally, as we look long term, the trend is upward and will continue to be upward for quite a while. That's the limited quantity, portion of Bitcoin. But
And we know that there's another halving coming. I don't want to glaze everybody's eyes over, but it does become more difficult over certain periods of time. And many miners are viewing the concept that they want to get as much done between now and the next halving. So as a result, a lot of people, are holding in anticipation that at the next halving, the difficulty doubles, so the yield becomes half for that same amount of work. And at that point, the asset will become more valuable, maybe less valuable. I don't know.
long-term more valuable.
Yes, long-term more valuable.
So I'm interested, you also mentioned this briefly. At the end of this process, as we see on the slide, you're holding this thing called a Bitcoin, right? Which you're actually not holding, but virtually you are. Is that something that you all are converting to US dollars? Are you holding it? And beyond maybe what you all are doing, are you seeing a trend in terms of who's interested in getting in? Is it because they want the Bitcoin because it's to turn it into dollars today, or they really want that Bitcoin to be the asset they come away with?
I think generally, from a larger Bitcoin miner perspective, most are in the process to hold their Bitcoin, to hold it for longer. And as Magellan Scientific we're doing that very thing. We're mining Bitcoin on a daily basis, and what we're doing on a typically monthly basis is using that balance of Bitcoin as collateral under various structures that we work with our financial partners on to monetize part of that into U.S. fiat currency to help pay our operating costs. But I think a lot of larger miners, publicly traded miners, are in it more to hold or hodl, for those on the inside, the Bitcoin than sell it.
So, and again, my philosophy is a little different. We're selling about half, and our plan is to accrue about half, so that we're covering our operating costs, and at the same time letting the mine pay for the development improvement of the ASIC application-specific integrated circuits, which is what the miners are. They're ASIC miners, and they're specific to Bitcoin. That's what we're mining. Keep improving my stock and using some of the money for maintenance and ops. So it's just two different schools. I don't know that either one is right or wrong, quite frankly, but we'll find out.
So one of the reasons we've invited the two of you to speak on this topic is because you've been spending time doing this, and you've hopefully seen some things that a new person might not. What lessons have you learned that you wish you knew back when you were getting started?
Want me to take this one?
I'll just say weather matters.
Oh, yeah.
Weather matters. We know that, we know the oil and gas business. It's hard to operate in the wintertime. Gosh, it's hard to operate a data center out in the middle of a field in the wintertime too. And then summer's hot. So those are the things we fight, are the extremes of weather. And the miners are difficult. They're temperamental little pieces of equipment. They don't want to be abused. So you need to create a nice operating environment for them. We've learned that. So.
Yeah, weather's great. I mean, we didn't touch base on that when we spoke before. That's a really interesting one. And the folks here that are involved with Magellan know that weather's tough to deal with. But besides that, one piece that I wish we would have known about more when we started this is the logistics of getting equipment shipped and delivered from Asia that we didn't expect when we were kind of reviewing our contracts. I mean, we knew they were coming from overseas. We knew there were questions on, carriers, delivery, eco terms, or what they're called, or I forget what they're called, the shipping terms. But it's something that we were unaware of. We're just not familiar with that side of the business. But going through it a couple times, we had to learn quickly. So.
You mentioned a little bit about supply chain. Is that something that you think, and we hear about that on the news, of course, all the time, as you are attempting to grow, is that something that you've seen as a problem, or is it resolving itself?
I think it's still a problem.
Yeah, very much so.
Yeah, these are
they're in demand.
Yeah, and the chips, the computer chips, are just in demand as this industry as they are in other industries. So you've got supply chain constraints in addition to strong demand. That when as you can imagine, the price and availability of the equipment is strongly tied to the price of Bitcoin. Mm-hmm. And so as that moves, the demand constrains just from people wanting more machines, let alone the supply chain concerns.
Yeah. You're seeing it similar in the way you're building your business, Bill?
Yeah, and of course, I'm more in the used equipment market, but it tracks right along. Mm-hmm. Tracks right along because it would be the alternative. And so there's competition for better equipment. People are continually upgrading. And as we mentioned earlier, as the difficulty improves, the older miners become less valuable because their hash rate, the amount of data that you're producing, per the yield, keeps dropping. So you're incentivized to keep improving the quality of your machines. Mm-hmm. And so that competition is ongoing, whether it's for the new machines or in the used market.
Yeah. So we've talked a lot about Bitcoin, but as I mentioned in my trivia question, it's only one of, say, 17,000 options. When you guys were getting involved, did you consider other types of cryptocurrency? And without glazing people's eyes, is there a reason why you chose Bitcoin? Do you think that's the logical choice for most people that would want to get involved in this type of business?
Yeah, from our standpoint, believe it or not, Bitcoin was the easiest to explain to people. We had considered and looked at other cryptocurrencies, like another well-known one is Ethereum, which is slightly different in its protocol and blockchain than Bitcoin is. But from our standpoint, there were other folks already mining for Bitcoin in places like the Permian, in the Bakken, on flare gas situations. So it was already a kind of a known thing, and it was easy to follow that path and talk about mining Bitcoin. But there's, like you mentioned, there's all different kinds of coins that at some point in time in the future may be more viable to mine something else than Bitcoin. But for right now, Bitcoin is, no pun intended, the gold standard in cryptocurrency.
It is, and it's essentially a fungible commodity or currency, although I think it doesn't want to be a commodity, it wants to be a currency. In the future, the whole concept of blockchain is going to affect all of our lives because it will be the most secure form of particularly financial data transmission, but all forms. And as that develops, the need for more and more, not just computing capability, but remote and non-disruptible, if that's a word, computing capabilities are going to become valuable. So at that point, maybe we're not even going to be looking at just our stranded assets. We could be looking at remote oil and gas because it is physically remote, having a value apart from anything else because that's what the market is going to want. Now, how they will find us or we will find them, that's a good question, but it's clearly headed in that direction, especially when we spoke earlier about I lost it, 3 letters.
I lost it too.
NFT?
NFTs.
NFTs, yes, yeah. Well, and can I for 1 second build off what Bill said? What's really interesting, and this is a bit of 30,000-foot view, what's really interesting with mining Bitcoin is we go where the energy source is. We don't have to have the energy source come to us with traditional electric lines, right? Our entire electrification since for the last 140 years, whatever it's been till now, is to put electrical generation near population centers and then put transmission lines out to the people who want to use it. We use electricity right at the fuel source. So you think about remote locations that have reserves for fuel that aren't near any kind of a pipeline. All of a sudden, those locations are now economic and viable. And that's a step change in the way we look at the use of electricity and the generation of electricity. It's a fascinating piece.
Yeah. So as you look, we're nearing the end of our time. We'll leave a little time for Q&A.
Yeah.
Let's ask a forward-looking question. Where do you think things are going? And what interesting things do you think are maybe around the corner?
Well, just what we were picking at, that there'll be, right now, in terms of just this sector, the amount of energy that's consumed is about equal to the energy consumption of France. So it's an enormous sector in itself, and it will only grow. I believe that there's, just as you were alluding to, there's a lot of things that we don't know are going to come at us just because of things like NFT, banking needs, all sorts of people that need multiple backup, reliable, remote, secure data sources. And the better we can do that and provide the reliability and the security, the more valuable our assets become, which is what you were talking about earlier, is that you've leveraged up the value of your asset.
There's no doubt, and I think that we have this same slide up here, and this is a good segue to this component. In this slide, we've got the outcome from the data center is mining Bitcoin. But the reality is we're providing low-cost electricity into a modular remote data center for a variety of applications. Right now it's mining Bitcoin. Tomorrow it could be company-specific artificial intelligence applications. It can be high-density computing around maybe a manufacturer-specific blockchain. It could be redundancy. And the remote nature of this, the off-grid nature of this, provides a whole bunch of security that is unique to this process. So where it's going, we don't know, but the applications are far beyond just mining cryptocurrencies or mining Bitcoin.
Right.
Yeah, I think that's we brought that up this morning, a really interesting concept, and really gives people some thoughts if they've got wells out there. There could be a lot of things to do in the future, for sure. Okay, do we have any questions from the audience? Yep, is someone going to bring
Questions for our speakers?
Here's a microphone for you. Get your hand up, he'll come to you.
First question right here.
Bill, I will apologize in advance. I met you in the hallway and said I was looking forward to your talk, and your quick response was just don't ask any questions. So I am sorry, but I just have a quick question on this. I'm not very educated on it. Your background is absolutely drilling wells, return on investment, those kind of things. When you consider this compared to traditional drilling a well, return on investment, is there a lot higher financial risk of getting your return on investment or covering your operating costs? Bitcoin to me sounds very volatile and risky. So is it a more risky investment opportunity this way compared to a traditional drilled well?
Well, again, we talked about that at breakfast, and at this point, we cover our operating expenses. We do make some money. It is not a golden flower that we found in the bush. It's a lot of work, takes a lot of effort, it's a lot of equipment and a lot of capital. My metrics are about the same return on an investment as an oil and gas well, I believe. I'm just a year into it, so we're pushing along that. But I won't say that for us that this is some great pie in the sky, but it has allowed us to operate and produce oil that we would not otherwise have. So we've got income streams that we would simply not have had but for having this. But to stand alone on its own, it'll do okay. It will pay out. We will make money. But I'm not trying to present it as some huge, enormous opportunity. It is an opportunity, but
Well, yeah, and I think that it aligns very close to the same sort of thesis that you have when you drill a well, right? When you drill a well, you're putting a lot of capital up front day one, and you've got a well that produces revenue, and you have relatively small operating expenses relative to the revenue you're making each month from the well. And that spread will pay back the investment to drill the well. This is the similar. It's a lot of capital up front, and you've got relatively controllable operating expenses, and you have good revenue, but what you need to do is make sure you generate that rate of return on the investment. And there's stuff that we do in particular, we use various hedges and other kind of commodity price risk management tools to try to lock in those returns, which there's a very robust futures market around Bitcoin trading. So those things help a little bit, but like Bill said, it's not necessarily easy.
So
Ryan, next question here.
Yeah, one second. I want to throw something out for the good of the order on that. These folks are both vertically integrated, right? And so they own their wells, they own everything on the screen. I know from a transactional point of view, if you don't have or don't want to invest that capital, there are lots of folks out there who have the other pieces besides the wells that'd be interested in talking to you.
Yep.
Okay, so that's also an option. There's a way to get in this
you
without
could
you
just
being
provide the gas. You could provide the gas and the
point.
electricity. You could provide the gas and the electricity and the data center. You could provide the gas, the electricity, the data center, and the ASIC miners. You could do all the components
Yep.
or just provide the gas. I mean, there's opportunities all the way across.
Yeah.
You're right.
Yeah, perfect. Okay, what's your next question?
Chris, I think this one's for you. If you look
Yeah.
at your schematic up there, I think you said that, quote, there's other modular off-grid applications for electricity. Do you have an example of that?
Yeah, so we know, like we've talked to some folks about high-density computing for, supporting company-specific AI applications or company-specific database applications. We've talked to some folks within the industry, midstream and E&Ps, that have the need for computing power close to where these data centers would be, these data centers could store that computing power. And the general thesis of all of that side is you're providing electricity to the data center at a very affordable price. Cents per kilowatt hour, cheaper than what you can acquire off most, grid connections. And as this evolves, I think those opportunities become more and more. Because we see other folks who are doing this in West Texas, in North Dakota, who are seeing those opportunities arise. And it's gonna continue to snowball.
And also, it's a good hedge in case the government is then trying to shut this down.
Well,
They can develop different directions.
Government regulation is always a wild card in that situation for certain. But yeah, that's right. That's right.
Ryan, we have two more questions, one right here.
Yeah, in considering Mr. Kinney, and you were talking about you're selling some of your assets to cover your costs and you're keeping the others aside. So how do you address the royalty payments out of that well production?
Each company is going to make their own choices. For me, I'm selling the gas at a price that is somewhat below market to my company that is generating the asset and then paying the royalty on that. The landowner has to be fairly compensated in some way. So this is my view, and it's worth no more than that. There needs to be a surface occupation agreement between the landowner and the generator, because it's not really oil and gas. It kind of is, but it's such an enormous asset and investment that you don't want to have it all out there and then find out that the landowner's unhappy. So I believe that has to be addressed. Now, I'm not going to say how you do it. So there's two parts to that, right? The sale of the gas and then the occupation of the site.
Ryan, we have the last question right here.
Okay.
Yeah, my question is more well operation related. If you have downhole issues and you have interruption in gas flow, and it affects the data, the generation of data, when you do that, when you have a rocky, erratic electric feed, how does that affect the overall, algorithm in the process of making Bitcoin?
Yeah, it's suboptimal, and our operation guys have guaranteed me that we have no issues whatsoever.
None.
That's what they told me. I mean, they're right over there, so they said it. But no, it's a great question, and the surety of gas flow produces the surety of electricity, which this is a 24/7 operation. So there's fail-safes in the pipeline that if we have under pressure, blockages, whatever else, the system just shuts down. And when the system shuts down, it shuts down from the generators all the way through the data centers, through our communication devices. And you can imagine we have, restart procedures that are, extra suboptimal in the wintertime, for example, because, you shut down these computers in the wintertime and they get ice cold, and when you turn them back on, you run the risk of damaging them. So surety of flow on the E&P side is critical, and that's been a consideration for us on where we deploy these, because we are reluctant to deploy them at a location that we might run into that issue. So it's a great question, but it's a critical piece of the equation.
And it's a fight you fight, so we'll have 30 days that we'll run, and then we'll be fighting for 2 or 3 days, get back up, and then we'll get a nice run time. And I know of other small operators that, they operate when they can. And even when you look at other, not natural gas-fired generation, guys that are doing solar, there's people that simply do it on cycle. So it isn't important that you run 24/7, but it sure works better.
Yeah, well, yeah.
Ladies and gentlemen, thank you, and please join me in thanking our speakers.
Thank you, Ryan. That was a fascinating discussion, gentlemen, and continued luck to you both on your new venture. Up next, we will have a discussion from some legal experts about the issues we are all facing. Please welcome Jay Carr, Timothy McKean, Christopher Barnozzi, and Mark Hilton.
You want to sit first? Sure, why not? Sit in order, I guess. Yes, sir. I was scared the
All
screen
right.
was going to be small.
Good morning, everyone. My name is Jay Carr. I'm a partner at the law firm of Vorey Sater, Seymour Peace here in Columbus. And it's my honor to moderate this year's legal update. We have three excellent attorneys here with us this morning to update the industry on changes in case law, both in Ohio and the Appalachian Basin. Although there has been some developments in Ohio case law, both at the Supreme Court level and the appellate court level, 2021 has been somewhat of a slow year in terms of oil and gas law development. So one of our speakers is also going to be talking about emerging legal issues that are taking place in West Virginia and Pennsylvania as they're likely to migrate here to Ohio. Our first presenter this morning is Mark Hilton. Mark is a senior attorney at Vorey's. He specializes in title and due diligence review. He's also a key member of our firm's regulatory team. Mark will be speaking and presenting on the Ohio Marketable Title Act and Ohio Dormant Mineral Act, two statutes that continue to plague both industry and landowners alike. Mark.
Thanks, Jay. Thank you very much, Jay. My name is Mark Hilton, and like Jay said, I'll be speaking with you about the Marketable Title Act and Dormant Mineral Act and recent case law coming out of the Supreme Court of Ohio and the 7th District Court of Appeals. The MTA cases are going to be focused on two exceptions to marketable record title, the first being the specific reference exception and the second being the title transaction exception. And the DMA cases are going to pertain to the reasonableness of the surface owner's search prior to publishing the notice of abandonment in a newspaper. So to set the stage for the case I'm going to be talking about, in late 2020, the Supreme Court issued its decision in West v. Bode, and I won't get into the details there, but ultimately the question was whether there was an irreconcilable conflict between the DMA and the MTA such that the more specific provisions of the DMA superseded and controlled over the MTA. The Supreme Court held that there was not an irreconcilable conflict and that the statutes provided two independent alternative mechanisms for terminating severed mineral interests in Ohio. That's why I'll be talking to you today about both MTA and DMA cases following West v. Bode. So the first case I'll talk about in depth is Erickson v. Morrison, which was issued by the Supreme Court of Ohio in early 2021. Here, in the early 1900s, the grantors conveyed the subject land, accepting and reserving therefrom all coal, gas, and oil. And the reservation language included a number of rights associated with the development of those minerals. And the surface owner's root of title and subsequent conveyances in their chain of title essentially contain a recitation of that initial reservation. There was an omission of a couple words that were non-material to the actual severance. And the current holders of the severed mineral interest brought suit, and the trial court held that the reference was specific, and therefore the interest was not extinguished under the MTA. The appellate court actually reversed and held that the reference was general because it did not identify the mineral reserver or the current holder of the mineral interest. So this was appealed to the Supreme Court of Ohio, and relying on Blackstone v. Moore, the surface owner argued that because the reference did not include recording information for the severance deed, it needed to identify the mineral owner to be specific. The Supreme Court of Ohio disagreed and applied the Blackstone v. Moore three-part test, and ultimately held that because the deeds were made subject to specific, identifiable reservation of mineral rights using the exact same language as the severance deed, that the interest was not extinguished under the MTA. In contrasting, they said that the deed did not contain vague boilerplate language accepting a reservation that may or may not exist. And in coming to this determination, similar to the Blackstone court, the court used the everyday usage definitions of general and specific. And they also pointed out that there's nowhere in the statute is there language requiring the identification of a severed mineral holder for a reference to be specific. The next case comes out of the 7th District Court of Appeals, and it's O'Kelly v. Rothenbuehler. And here in the late 1800s, grantors conveyed the subject land, accepting and reserving all oil, gas, and minerals, including coal, and similar to the last case, listed a laundry list of associated rights. And the surface owner's root of title and a subsequent conveyance in their chain of title accepted oil and gas minerals, including coal underlying the land, and that was it. The current holder of the mineral interest brought suit, and the Court of Common Pleas held that the reference was general, and the decision was appealed to the 7th District. The 7th District agreed with the lower court and held that the interest was extinguished under the MTA due to the reference being general. Specifically, it said that the reference lacks any narrow, precise consideration, limited details or particulars, and the references were not verbatim restatements of the initial severance language. The references omitted the associated rights language, and they're susceptible to more than one interpretation. And the court said that this reads as vague boilerplate language. Having a technical issue there. So the next case is Cottrell Family Woodlands v. Ragsdale, which came out in late 2021. Here in the early 1900s, the grantor William Cox conveyed the land, accepting and reserving all coal underlying said tracts and 1/2 of the oil and gas. And again, a laundry list of associated rights were named. Here, the surface owner's root of title, but not subsequent conveyances, had a reference to this interest, and the reference was accepting and reserving all the coal underlying said tracts and 1/2 of all oil and gas with right to mine, bore, and remove the same, more or less, but subject to legal highways. The lower court held that the reference was specific, and therefore the interest was extinguished under the MTA. On appeal, the court held that the interest was extinguished because the reference was general. It said that the reference contains vague boilerplate language, and it omitted and added phrases to the initial severance. In addition, it was not consistently used within the chain of title, and it was just in the root of title. This case does, in my opinion, make it a bit difficult to apply this specific versus general test in the 7th District because the reference includes 1/2 of the oil and gas. It's a specific quantum tied there. And the court said, one factor to consider is whether the transfer of the surface rights contains vague boilerplate language, accepting any reservations that may or may not exist. And if you look at the latter part of the reference, it says subject to all legal highways, which to me reads as just that. It is, subject to any legal highways that may or may not exist. And if you contrast this with the initial language in the reference, all of the coal and 1/2 of the oil and gas, that just seems to be a bit more specific. So another case regarding the MTA came out of the Supreme Court of Ohio just a few weeks ago, actually. And one issue the court addressed, because it was a big part of the lower court decisions, was whether the severed interest was a life estate or a fee simple estate. And prior to 1925, words of inheritance were needed to create a fee simple interest. So whether the severance was a reservation, which is the creation of a new right, or an exception, which is an already existing right, would play a role in whether the severed mineral interest owner had a life estate or a fee simple interest. Ultimately, the court said that because the right to receive future royalties is a present real property interest in existence at the time of the severance, that it was an exception, and therefore the severance at issue created a fee simple estate and not a life estate. Turning to the MTA issue in this case, the question was whether a decedent's recorded will, in this case, was a title transaction preventing the extinguishment of the interest under the MTA. The facts were a bit complicated, but Jones ended up with an interest that went to Earl Ward, which I'll refer to as the Jones interest. Earl Ward died, and in 1972, his will was filed with the Monroe County the Monroe County Probate Court, and this is within 40 years of the root of title. So the court had to address whether or not this was a title transaction exception preventing the extinguishment of the MTA. Here, it's very fact-specific because the decedent's will did not contain a specific devise of the severed mineral interest, nor did it include a residuary clause. As a result, the severed interest passed as if he had died intestate. And the court held, because of that, the will was not a title transaction affecting title to the severed interest. This leaves open the question of what happens when you have a decedent who died intestate and whether the probate record as a whole would constitute a title transaction savings event, or if you would need a separate transfer out of that estate, such as an administrator's deed. In theory, a probate record should be sufficient because the revised code treats transfer by descent and an administrator's deed as two separate examples of title transactions. Turning now to the DMA cases, in late 2020, the Garrity case was decided by the Supreme Court of Ohio. Here in Guernsey County, the grantor conveyed land reserving all the minerals, and then a certificate of transfer from that grantor's estate conveyed the mineral interest to Jane Richards, and it listed a Cleveland address for Jane. There were no further transfers of the severed mineral interest, and there was no further information regarding Jane Richards in Guernsey County. Jane Richards died in 1997, residing in Florida, and her estate was prorated there. Here, the surface owners searched Guernsey County public records, and then went on to search the Cuyahoga County public records, where her Cleveland address was. They didn't find anything regarding Jane or her heirs, so they sent a notice of abandonment via certified mail to her Cleveland address, which was returned undeliverable. At that point, the surface owners went on to publish the notice of abandonment by newspaper publication. Here, the lower court held that the surface owner's search was reasonable, and therefore the mineral interest was abandoned with the DMA, and the appellate court agreed. I'm sorry. I can't get back. Yes, the appellate court agreed. So the Supreme Court of Ohio rejected requests for a bright line rule from both sides. The mineral owner wanted to require an internet search in each case, and the surface owner wanted to limit the required search to just the surface owner's chain of title. The Supreme Court refused to do that, and instead said what constitutes reasonable diligence will depend on the facts and circumstances of each case. It ultimately held that the surface owner's search was reasonable because they searched the county where the land was situated, as well as the county of Jane's last known address, and finding nothing, they were able to publish the notice of abandonment via publication. Here in Beckett v. Rosa, a late 2021 case established by the 7th District, in the mid-1900s, a landowner died, leaving land to Leroy and Grace, and the probate records for that landowner gave a Connecticut address for Leroy and an Illinois address for Grace. They later conveyed the interest in the land, reserving all of the minerals. There was nothing further in county for Leroy or Grace to transfer the mineral interest or evidence of their death. An attorney for the surface owner searched just those county records where the land was located, and they went on to publish the notice of abandonment via publication. The 7th District held that the search was not reasonable under the circumstances because they should have searched outside of the county where this land was located based on the addresses for those parties found in the probate record. Therefore, based on the information in those probate records, you need to search outside of the county because the county search only establishes the baseline of a reasonably diligent search for the surface owner, and that was established in the prior case, Garrity. That's all I have. I'm happy to answer any questions after the presentation. Thank you.
Thank you very much, Mark. I think the key takeaways from Mark's presentation is as much clarity as the Supreme Court of Ohio gives us on the MTA, there's still some ambiguity as how the law is being applied at the appellate and trial court level. And so when it comes to oil and gas development, be sure to look at your title opinions, look at your curative requirements, making sure that you're taking the necessary actions to protect yourself, regardless of how a court might ultimately arbitrate the issue. And with respect to the DMA, as the 7th District Court of Appeals has said, what is a reasonable search depends upon the facts and circumstances. There's no bright line test. So you really need to scrutinize what the surface owner did to abandon the minerals when evaluating whether the abandonment was proper. Our second presenter this morning is Tim McKean. Tim is a member at the law firm of Steptoe and Johnson and a member of the firm's executive committee. Tim specializes in title and due diligence in mineral acquisition matters. He has authored AAPL's Ohio Comparative Law article, and he has spoken at numerous presentations ranging from EMLF to AAPL and local layman associations. And Tim is going to be speaking on developments that are taking place in both the Commonwealth of Pennsylvania and the state of West Virginia.
Thank you, Jay. Appreciate it. Good morning, everyone. So just as we were putting this presentation together, one of the things we thought about might be useful for folks is a little bit of an update on what's going on in West Virginia and Pennsylvania. And since I work in Wheeling, I'm kind of close to all 3 states, licensed in all 3 states, so I decided to take that one on. There's not a whole lot going on in those other states as well, but I think it is useful for us to sort of see what some of our neighboring states are doing so that we might know how some things may turn out or different litigation matters that might pop up in Ohio. And of course, you know, it's in places like Ohio where our case law maybe is not as developed as others. It is important to kind of keep an eye on some other states, what happens, and as our courts may adopt some similar approaches from some of the other oil and gas producing states. So hopefully it's relevant. And just a quick show of hands, does anybody have any assets in West Virginia they're actively working? Anybody? Okay, I know one of our attorneys does some work in West Virginia. Anybody in PA have any active assets that they're working? I got one hand. Okay, so this presentation will be relevant for one. No, I think it is relevant for us in Ohio because it is important to keep an eye on what's going on, and we'll try to keep it obviously as high level as we possibly can to keep things moving. So what's going on in West Virginia? We'll start with that. I got 2 cases I want to talk about and an update as far as their judicial system in West Virginia that's picking up something new that hasn't been around ever in the history of the state. So we'll talk a little bit about a post-production case called Kellum. And post-production issues and post-production costs are obviously a hot topic for a lot of us. And certainly in West Virginia, that's a big issue. And we'll talk a little bit about that. And then there's another case about tax assessments. I know that's extremely riveting, but we'll talk about that and how West Virginia does their tax assessments a little bit. And then the interesting thing in West Virginia, from someone that's a member of the bar there, is West Virginia is just starting this year having an intermediate appellate court. So when we were talking in the last presentation about, you know, the 7th District Court of Appeals in Ohio, that type of thing, West Virginia never had an appellate court. And so it's kind of an interesting development that you were either at the trial court or you went all the way to the Supreme Court, and the Supreme Court could decide not to hear appeals in West Virginia. And so that was always thought to be somewhat unfriendly towards businesses, particularly if you had a bit of a runaway jury with a huge verdict, and then the Supreme Court would refuse to hear an appeal. So after many years of prodding from the business sector, West Virginia has adopted an intermediate appellate court. So I think that should be a positive development in West Virginia to try to curtail some of those instances perhaps where the juries award some large verdicts against various companies as they kind of get a little bit out ahead of themselves, if you will. So let's talk a little bit about the Kellum case. And so this is really down in the weeds a little bit of post-production costs. But what this case is, this is a case from the Northern District of West Virginia. It sits in the Judge Bailey, who's mentioned there, is the federal judge in Wheeling. And so this is a federal court case, but it's a federal court case applying West Virginia law, and it's about post-production costs. And so what a federal court can do if they have questions about how a state court would rule on something is they can do what's called issue a certified question. And so Judge Bailey's issued these certified questions to the West Virginia Supreme Court of Appeals, which hopefully they will answer. Their oral arguments are set to happen soon. And one of the big questions is the case that's called the Tawney case, still good law in West Virginia. And for those of you not familiar with the Tawney case, we'll have a slide on that in a second, but that's the landmark case in West Virginia about post-production costs. And so in this particular case, you can see some of the issues there on the slides, but what's meant by the method of calculating the amount of post-production costs? Can you just do a simple listing of what post-production costs will be? Or, is it going to have to be a more calculated formula, those types of things? And then also a question about, are they limited to direct costs, or can you do some indirect costs? So that'll be an important case. That's going to come out soon, hopefully this year, and that should give a little bit more guidance in West Virginia, because this case called the Tawney case from 2006 that you might remember for some of you that have been around for a while. This was a case that was marked West Virginia as a bit of a state that, we'll say, follows minority rule and sort of an out-of-market approach, if you will, to post-production costs. And in that particular case, the lessee had to bear all costs incurred for exploring, for producing, marketing, and transporting oil and gas. Basically, as you can see there in front of on the slide, I mean, unless the lease expressly permitted certain post-production costs, then those costs couldn't be taken in West Virginia. And so that was kind of an interesting, let's say interesting development. It depends on your perspective, I suppose, but it made West Virginia a bit of an outlier in terms of how post-production costs have been handled. And so that's still out there in West Virginia, and something to keep in mind if you are working in West Virginia. So there's another case in this line of cases called the Leggett case, and that's a relatively recent case. And in the Leggett case, they kind of unwind a little bit of the Tawney case. And so overall in West Virginia, if you think about the politics of West Virginia, the Supreme Court has gone from, when I started practicing law in 2006, to be considered a very pro-plaintiff type of Supreme Court, to now being a court that's considered to be, at least compared to where they were, a more business-friendly court over the last 15 or 16 years. So that's been a bit of an interesting development. So that Tawney case is obviously a very landowner-friendly case where you can't take post-production costs from the operator side. And so they kind of wound that down a little bit with the Leggett case recently. And Leggett's a little bit different because it has to do with the flat rate statute, with the flat rate royalty, so it doesn't totally overrule Tawney. For those of you that are in that to those legal issues like stare decisis and those types of things. But it is a case that indicates that the court may be willing to allow a little bit more in terms of post-production costs deductions in West Virginia. And so that's something to keep in mind. And then the court also talked a little bit in the Fourth Circuit, which is a federal court, but the federal court interpreting West Virginia law talks about that West Virginia doesn't demand an exact Einsteinian proof for calculating post-production costs. So, so in West Virginia, these cases are still out there. They're still pending. This one, the Kellum case, that's going to be in front of the West Virginia Supreme Court, should be pretty interesting to determine whether the court's going to really maybe turn the corner on some of these post-production cost issues, or whether post-production costs will still be a larger issue in West Virginia. And so, those are types of things we'll probably continue to see more litigation on different types of costs in Ohio over time. And so something to keep in mind. West Virginia is certainly they went down a different path early on than Ohio has. So the relevance to Ohio is, I think, really more in the fact that just be aware that landowners do challenge these things from time to time, and it can become a big issue. But hopefully Ohio is a lot more friendly environment on those types of things than West Virginia's been over the last few years. The other thing, if you operate in West Virginia, that's been an issue, and we don't see as much of this in Ohio, but is the different tax issues that they have with respect to the tax assessments. So in Ohio, where maybe minerals weren't severed quite as much, or if they were, no one really was keeping track of the severed mineral interest from a real estate tax perspective until relatively recently. In West Virginia, they've had a lot of tax assessments over the years, and they haven't always done the best job of keeping track of those things. And so their tax assessment situation is a little bit all over the map. And so you have these tax sales, so people will stop paying their taxes, and then they have a tax sale, and then someone else will buy up that interest, and then all of a sudden, much like a Dormant Mineral Act or a Marketable Title Act situation, you get these competing chains of title, which are problematic. And so there's a recent case from November on a tax sale issue. In this particular case, the minerals had not been severed, but the local county assessor, which is the equivalent of sort of the auditor's office in West Virginia, the assessor had placed a separate assessment for the royalty interest, and that separate assessment was never paid, and then ultimately was sold at a tax sale. And so then you had these two competing chains of title. And basically you can see the question presented is whether the assessments and the royalty interest in the wells was properly assessed and sold. And the court basically said, no, it was an improper assessment, and therefore the the lease from the surface owner, the unsevered mineral side was the proper title, and so that tax sale was invalid. And so the thing to keep in mind in West Virginia is that these tax sales, if you're dealing with them, it can pop up and bite you if you have some competing chains of titles, those types of things, because of the separate assessments. And that's not a real great situation there with respect to those separate tax assessments. In Ohio, at least in my experience, we don't see a lot of issues related to this. A lot of times if minerals were severed, they weren't properly assessed. There was really not a lot of mineral assessments, at least in my experience, until more recently, when now, of course, the counties are paying a lot more attention to that. And that's also an important issue for your Dormant Mineral Act analysis in Ohio, because if someone would be paying taxes on a severed mineral interest, then obviously it's a block to any kind of Dormant Mineral Act claim. So something to keep in mind on what's happening in West Virginia on this Orville case. And so those are three things that were going on in West Virginia that might be of interest. You have the new Court of Appeals, which I think is a good development. You have the West Virginia Supreme Court considering maybe rolling back some of the more draconian parts of their Taney decision on post-production deductions, which also is probably a positive development. And then also dealing with just some of these tax sale issues that pop up in West Virginia. And so that's what's been going on over there, not a whole lot. Our friends in Pennsylvania, I think they have sort of a bit of a reputation on the regulatory side of being a challenging state sometimes to work in. Their cases in the Supreme Court have actually turned out the last couple as being a little bit more more operator friendly, actually. And the first one was an interesting case that was tried where the actual state of Pennsylvania, or the Commonwealth as it's called, this Commonwealth versus Chesapeake. And basically the idea behind this case was the Commonwealth of Pennsylvania was using its authority through the Attorney General on behalf of the Pennsylvania citizens to use Pennsylvania's unfair trade practices and consumer protection law. So it's sort of like a consumer protection type claim. And they basically were trying to use the power of the state and the Attorney General and this consumer protection law to say to various oil and gas deals that had happened that consumers weren't being protected, people were signing leases for less than market value and those types of things, and therefore the state was going to sue operators to say that this unfair trade practices applied to them. But the Pennsylvania Supreme Court, in its holding in this case relatively recently, determined that operators were really not the sellers, and so to have an unfair trade practice to protect a consumer, you had to have a seller had to be the one that was violating it, and the Supreme Court was able to say that really the consumer protection doesn't apply in those cases. So this was a move, obviously, by Pennsylvania. Pennsylvania's had some luck with different I'd say luck, but say from the landowner's perspective, Pennsylvania has a lot of different regulations based on townships as well, that they've been able to limit development through the use of having township approvals for certain things, that type of thing, as you guys probably know, which we don't have to deal with in Ohio. But one other thing that they had tried that I guess could come to us in some form or fashion, some type of statutory approach to trying to break some leases, was also a failed attempt in Pennsylvania. And there's one other case I don't have a slide for in Pennsylvania, but it also deals with a lease breaking issue. And so in this particular case, there was a lease on a property. There hadn't been a lot of production. The lease provided for a default provision, which basically said, okay, if there's no production, then the lessor has to give notice and a right to cure to the lessee. You guys have a lot of leases like that probably, right? And so the lessor actually just went straight to court to say the court should invalidate the lease. And believe it or not, the Pennsylvania Supreme Court said, no, we can't invalidate the lease because you still have to go through the remedy of trying to have the lessee cure this particular lease. So that was a good case for operators as well in terms of keeping some leases in place when you had that right to cure in Pennsylvania. So those are just a few things to keep in mind. It was kind of a quiet year or so over across the Ohio River and across the border, but there could be some things popping up over there that may find its way over to our side here soon. So with that, I'll give you my material disclaimer, and I'll pass it back to Jay. Thank you, guys.
Thank you very much, Tim. As you said, case law from other oil and gas producing jurisdictions do often find its way to Ohio, especially when Ohio courts are considering novel issues. Our last speaker this morning is Chris Baranzi. Chris is a partner at the law firm of Porter and Wright here in Columbus, and his practice focuses on matters pertaining to energy law and related real estate matters. Chris has extensive knowledge when it comes to oil, gas, coal, and pipeline issues, as well as electric transmission and land disputes. He is the author of the firm's energy blog, and in addition to reviewing title and due diligence matters, he often litigates disputes between operators and landowners when it comes to petroleum products in natural gas pipelines and the use of eminent domain. Chris is going to be speaking on post-production costs as it currently exists here in Ohio. So please welcome Chris.
Thank you, Jay. So as Jay said, I'm Chris Baranzi, partner at Porter Wright, and I have the privilege to talk to you about post-production costs. I am very aware that I am the last speaker before a lunch break on the last day of a 3-day event, so I promise I will make a discussion of post-production costs as interesting as possible. But what would a legal presentation be without a robust disclaimer that's required by the non-lawyers in my firm, ironically? So there it is. If you want to read that more, come see me after the presentation. So we're going to start with sort of an introduction to what we're talking about today. And I assume that probably the vast majority of us are familiar with post-production costs and sort of the legal issues involved. But for the rest of us that want to know what we're talking about, I've got a couple of slides here. Post-production costs is just like it sounds. It's costs that are incurred after gas is produced at the wellhead. It's compression, dehydration, transportation, processing, that kind of thing. All of the processes and costs that are incurred to move that gas downstream to sell it at a higher price and to add value to it. And so the legal question that always arises is who's got to bear the financial burden of those costs? Is it the operator or is it the lessor? Are we allowed to deduct those costs from the lessor? And that's what virtually all of the legal cases about post-production costs are about. So it's become a hot topic in Ohio in the last handful of years for a number of reasons. I think mostly, as I say here, it's about the shale. You know, before we had horizontal drilling and production from the Utica and Point Pleasant, mostly we had vertical wells that were producing a different kind of product and didn't require as much processing and certainly treatment, things like that. And so we have more costs now than we did before. We also had deregulation of the natural gas markets in 1992, which changed how gas is bought and sold and where. And then the other feature of Ohio is that a lot of the production, even the modern production in our horizontal wells, is dependent upon older leases, some signed very commonly back in the 1970s, 1980s. And at that time, no one was thinking about the complexities of modern shale drilling and the kind of product we were going to get. And so coincidentally, or I should say, just a function of the time, was they had very simple and short royalty clauses. And so trying to apply a different era to modern technology, and so that's created a lot of the legal questions. So generally speaking, this is the last of my introductory slides. Generally speaking, you'll find in the world of post-production costs, legal decisions, you see discussion about two different camps. And states often divide themselves among one of these two camps. The first is a marketable product camp. You have marketable product states that say that it is the operator's obligation to take the oil and gas, put it in a marketable form, incur whatever costs are required to do that, and sell it wherever it can be sold, and then the lessor gets the benefit of that higher price. And so in the marketable product state, the operator bears the financial burden of post-production costs. The other camp is the at-the-well camp, or at-the-wellhead. At-the-well states say just the opposite of the marketable product camp. They say that if the gas is to be valued at the well, but it's sold downstream, not sold at the well, then to get the value at the well, you have to deduct, or they would say a lot of times net back or work back those costs to try to figure out what the gas is worth at the wellhead. So you ask yourself, what about Ohio? What does Ohio do? To talk about Ohio, we need to start with the Lutz case. So Lutz actually started as a Northern District case in federal court. It was a class action by a number of lessors. They felt like they should not bear the financial burden of post-production costs, yet post-production costs were being deducted from their royalty, so they filed suit. The federal district court, its job is not necessarily, in any case, not necessarily to pick one legal theory or another as it feels is best. Instead, a district court, a federal district court, its job is to apply the law from that state. So it asks itself, what would Ohio do? Not what do I want to be done or what do I think is best? What would Ohio do? And so the district court in Lutz looked at the law and it couldn't tell. It said, I don't know what Ohio would do. And so what federal district courts do in that situation is they certify a question to the Supreme Court. And so they go to the Supreme Court of that state and they say, tell me what the law of Ohio is. And so here we have the certified question of law that was presented by the federal district court. This is what they asked the Ohio Supreme Court to answer. Does Ohio follow the at-the-well rule, which permits deduction of post-production costs, or does it follow some version of the marketable product rule, which does not allow deduction of post-production costs? Now, I'm sure if you were the federal court judge, you got a very unsatisfying answer from the Ohio Supreme Court, because they refused to answer that question definitively, or maybe they gave an answer that the district court judge wasn't expecting. And they said, Ohio is neither. They said, Ohio has a law, a well-developed body of law about contracts, and a lease, an oil and gas lease is a contract, so look at the lease. And they said to the extent that the lease is ambiguous and would require us, therefore, to consider other circumstances, we don't know anything about those other circumstances, so you, federal court, take the evidence and figure it out. And to the extent that the lease is clear and you just need to read the lease, well, you can do that as well as we can, so do it. So they decertify the question, send it back to the district court, and that's what lawyers would call Lutz 2, is the proceedings that occurred after the Ohio Supreme Court case. We did get a decision from the federal district court, and this is the royalty language I have quoted here. They looked at what I have underlined, this phrase, market value at the well, and their conclusion that was under that royalty provision specifically, Ohio would use a at-the-well rule. Now, they weren't saying that Ohio would use at-the-well under all circumstances, but specifically for those leases, they applied an at-the-well rule. They found that the leases were unambiguous, and so they just read the lease. They said it says we value this gas at the well. At the well allows you to net back the costs, and so that's what they allowed to do. They granted summary judgment to the operator. It was certainly a very favorable decision for the industry. So that was 2017. The lessons we learned from Lutz sort of set the stage for a lot of the other cases that arose. Number one is sweat the lease language. And I cannot tell you the excruciating detail with which lawyers who are dealing with millions of dollars at stake and are highly paid, how they will parse lease language and what phrase modifies what other phrase and what the comma means here and why there's no comma there. I mean, it is amazing. It is as down in the weeds as anybody could get about, a specific contractual provision. And that's what we see in these cases over and over again. It is, an argument over minutia of lease language. Another lesson from Lutz is Ohio does not have a default at the well or marketable product rule. You look at the lease. Although I will say, overall, the body of case law in Ohio has been very favorable to industry, and we see an at-the-well rule kind of decision come out time after time. Other lessons from Lutz is that principles of contract construction are key to the analysis. And so again, we see time and time where the courts just focus on the contract. We've seen several times the courts refuse to consider other contracts or other what they would call extrinsic evidence. They just look at, we would say, the four corners of the document and interpret that language. When they look at the document, you'll see that a theme in the cases is one of the primary drivers of the analysis is where does the oil and gas royalty provision say that the gas should be valued? So where does the lease say value the gas for purposes of the royalty? Once you figure that out, most of the analysis flows from there, and a lot of times that determination will override whether there's words like gross or cost-free or without deduction in a royalty clause. So from one of the seminal cases from 2017, now we jump forward to one of the most recent cases, the Zettenbauer family land case. The Sixth Circuit just affirmed the lower court's decision in this case February 1st of this year. In that case, we've got the royalty provision here quoted right up front. I've underlined some of the key terms that the court focused on. Gross proceeds paid to the lessee should be used to calculate the royalty. Got this phrase, marketed and used off the lease premises, and the royalty is computed at the wellhead. This particular royalty provision was actually very long and nuanced, and it provided for situations where the gas would be sold to an affiliate, and seemed to be very thorough. As it turns out, a lot of times the more words somebody writes, the more confusing it is, the more opportunity for argument. And so you ended up in, there was another class action, again in the Northern District of Ohio Federal Court. The background here is interesting, and we see this structure from the Zettenbauer case several times in case law. So what had happened in Zettenbauer is we had two operators. They were producing wells. They would take the gas that was produced at the wellhead. They would sell it to an affiliate. That affiliate would then transport it, process it, do all the things that were needed to sell it downstream. When they sold it, they would take that downstream price. They would net back or deduct all the costs that they incurred to get that downstream price. And then once they went through that calculation, that's the price they used to pay the operator who sold the gas at the wellhead. Then that operator, that's the first time they got paid, they would take that amount of money and they would calculate the royalty and pay the lessor. From the operator's perspective, they were paying gross proceeds. They were paying the gross amount of what they got. From the lessor's perspective, they looked at these affiliate transactions, the fact they weren't getting the downstream price. They were very irritated. They filed suit. They said these are improper deductions of post-production costs. They raised a variety of challenges, attacked the royalty language in a variety of ways, but it didn't work. Sixth Circuit, the Northern District granted summary judgment to the operators, and the Sixth Circuit affirmed. The Sixth Circuit's decision here, I pulled out some of the language. They say, though the lessees are receiving an amount that is net as to the downstream affiliate, it is not net from the lessee's perspective. The plaintiff's royalties are based on gross proceeds paid to the lessee. And this reading not only squares with the, and they quote some of the lease language, without any deductions or expenses language in the affiliate clause, but it also reaches a fair result, avoiding a windfall to the landowners. So we see in the Zettenbauer decision some reflection of Lutz and the lessons from Lutz. And one of those is an intense study of the lease language. Another is application of rules of contract construction, and specifically that last part about avoiding a windfall to landowners. You'll see that the court, they're trying to give the parties the benefit of the bargain that they struck as expressed in the lease language. They tried not to look at other principles of law beyond sort of a contract analysis. The other thing to be learned by Zettenbauer is that this was a very effective transactional or corporate structure by the operators, right? And I don't know whether it was deliberate with respect to this specific lease language. Maybe it was, maybe it wasn't, but certainly the effect was very favorable to the operators because the producer at the wellhead got to take their one payment and say, we're not deducting any costs from that, and figure out the percentage of royalty. If the operator had gone further and incurred costs, it would have been a much messier analysis. So other noteworthy decisions that we've seen in the last few years, I've flagged the Cunningham property management case. This was an interesting decision because in this case, there were really 3 claims that came out. There was sort of a typical one you'd expect. Lessors were challenging the operator's decision to take post-production costs and deduct them from the royalty. The second claim was they claimed that the deductions that were taken, even if they could be taken, were too high. And the third claim was that the operator breached its lease because it did not provide an accounting to the lessors. And so the first decision on point number 1 about whether post-production costs could be taken really is not particularly noteworthy. The royalty provision provided for the royalties to be calculated based on the wellhead price paid to the lessee. So the court looked at that. They said, we're using the wellhead. Wellhead is our point for valuation, and basically followed Lutz. The operator wins. Points 2 and 3 is where it got a little more interesting. On the claim that the deductions were too high, the operator filed a motion to dismiss, and the court said not so fast. They didn't say that the lessors win, but they did say the operator does not have unrestricted latitude in determining those post-production costs. They have to be reasonable. The lessors have alleged they're not reasonable, and so we're going to hear more about it. So that claim was allowed to continue, although we're not sure how ultimately it will turn out. And then the last claim was also interesting. The lessors claimed that the operators breached the lease simply because the operator did not provide an accounting. The operator said, well, hold on a minute. Number 1, the lease does not give you a right to an accounting. And number 2, the lease disclaims any implied covenants that you're using to say you deserve an accounting. And they asked for dismissal of that claim. And again, the court said, not so fast. In Ohio, there is always an implied covenant of good faith and fair dealing in every contract. A lease is a contract. And based on that particular implied covenant, in this situation where you have one party in control of all the finances and costs, in those situations, there could be a right to an accounting. And so that claim was allowed to continue. The last case that I've flagged as interesting is interesting for just a couple of reasons. Number 1, it's one of the few state court cases that addresses post-production costs. Gateway Royalty comes out of the 7th District, particularly Carroll County is where it started. I've quoted the royalty provision there for you at the top, but this case was interesting not necessarily because of the royalty provision, but because it was a claim by a very sophisticated royalty owner, Gateway Royalty. It made very sophisticated claims, made some nasty claims, including breach of contract, conversion, violation of the Corrupt Practices Act. The Conversion and Corrupt Practices Act claims were dismissed relatively early on. The breach of contract claim lingered. This is another case where Gateway Royalty, in particular, tried to use transactional documents and corporate documents to make their case that these affiliate transactions should be accounted for in some way and should come into play. But again, the court refused to consider those documents and said, we find the lease is unambiguous. We're going to look at just the royalty provision, and they did, in fact, rule in favor of the operator. And that decision was affirmed by the 7th District. So what's next? That's yet to be seen, but we're headed in the right direction for industry perspective anyway, because we've seen a clear trend of decisions that are favorable to industry. Hopefully those will have a deterrent effect. You know, as a lawyer, every time you see a royalty provision decided in favor of an operator, you think, well, that's one more provision that now has been dealt with. But you know, there is as many variations on royalty provisions as there are royalty owners. And so, you know, you're not going to see the end of these kinds of claims, but hopefully, you know, as the more cases pile up, we get some guidance about exactly what the courts are going to do. And I'm sure that, you know, resourceful plaintiffs' attorneys, they're going to come up with new claims. We've already seen claims for fraud and that kind of thing, where they claim that the affiliate kind of relationships and exactly how it's calculated, how the royalties are calculated, aren't adequately disclosed, and that therefore amounts to fraud. You know, we haven't seen any decisions on those yet, at least none that are unfavorable to industry, but expect those kinds of claims to continue. Thank you.
Questions for our panelists? Closing remarks?
No questions. We appreciate everyone's time. We're sorry we're
Bill,
over by
one question.
Oh,
Bill Kenny's got a question.
I'm sorry.
Question right here.
I meant to take my cloaking cape off. Because we had the cryptocurrency discussion before, I'm just curious how you think that, especially the last decisions that you were talking about, would affect paying a landowner, because now what is market price? Because the gas isn't going to market, and it's strictly an agreement that the producer is making with the cryptocurrency mining. And in the case where the producer is the cryptocurrency mining, he's making, you know, the left hand's making a deal with the right hand, which isn't real far away from what you were talking about earlier with affiliates.
Yeah, my thought on that is, you know, certainly it hasn't been addressed by the courts yet, but we have seen some disputes in the courts about what does the market mean. And so far, courts have turned to, you know, very common definitions. I mean, in one case, the court actually quoted from the dictionary. This is what a market is. And it's, you know, just like you'd think, it's a point where there are willing buyers and sellers and gas can be sold. And so, you know, maybe the existence of cryptocurrency exchanges and the flexibility there will change sort of the common understanding of what a market is, but certainly we don't have any guidance that I've seen from courts yet.
Other questions? Okay, join me in thanking our panelists.
Thank you again, gentlemen, for the updates. At this time, we will take a short break for lunch, and at the conclusion of lunch, prior to the Attorney General's remarks, we will have some video messages from Senator Joe Manchin and Congressman Jim Jordan. Thank you for having me today, and enjoy the rest of your day.